Good evening, ladies and gentlemen. First of all, I welcome all the distinguished panelists who have joined us on this occasion and express my heartfelt gratitude and thanks to all of them, especially to Justice A.K. Sikri for accepting our request at a very short notice. Sir, we are deeply grateful to you that you have kindly agreed to launch this book at a very short notice. I'm deeply grateful and humble to express my thanks to my Guru, Honorable Mr. Salman Khurshid, former Union Law Minister and presently Senior Advocate in the Supreme Court of India, for giving me liberty and full support and blessings to complete this task and to include very good friends from the academia, scholar friends. We are deeply grateful to eminent jurist and renowned legal philosopher, Professor Dr. Upendra Bakshi, former Vice-chancellor, University of Delhi, for accepting a request to become the special guest in the event. We are equally grateful to eminent jurist and distinguished parliamentarian, in fact, third time MP in Rajya Sabha, Dr. Abhishek Manu Singhvi, a scholar and a jurist with scholarship at heart. Both Mr. Salman Khurshid and Dr. Singhvi are great statesmen, politicians with scholarship at their hearts. We are deeply grateful to eminent Professor of Eminence, Dr. Ranbir Singh ji, for accepting our request to be a guest of honor in this event. Recently, Professor Ranbir Singh has retired from the August office of Vice-chancellor after serving this office for more than 22 years. He is a great institution builder who has been the founding Vice-chancellor of two universities, Nalsar Hyderabad and NLUO Delhi. Thank you very much, sir, for being with us today. We are thankful to Wolters Kluwer, its CEO, Mr. Sahai, who has published our book at a during very short time during this difficult time, Corona crisis. We express our sincere thanks to all the distinguished contributors who have authored articles on different aspects relating to the Indian Supreme Court and the Constitution. Mr. Salman Khurshid has authored a paper on balancing of fundamental rights in the light of Supreme Court's judgment in Anuradha Bhasin case and some other judgments. Mr. Yogesh Pratap Singh has contributed an article on judicial appointments. This is a very critical piece, and his findings are worth consideration and need serious attention. Professor Shruti Bedi has contributed a piece on judicial activism. Mr. Chirag Balian has contributed a piece on Chief Justice of India's constitutional role and powers. Mr. Asit Srivastava has also contributed a piece on CJI's constitutional status and role. In fact, this is the first time that I am seeing three pieces on the constitutional role of the Chief Justice of India. I have not seen such kind of contributions on CJI, where 3-4 pieces are there. And then we have friends who have contributed their articles on special leave petitions, curative petitions, public interest litigations, and Supreme Court and the social democracy. So this is a mix of various articles on relating to the functioning of the top court under the constitutional framework, and we are lucky to have a contribution in the form of foreword by eminent comparative law, constitutional law scholar, Professor Gary Jacobson from University of Texas. So the book, I think, is a very good contribution to the constitutional scholarship at this time when the entire humanity is struggling from the corona crisis. With these words, I once again welcome all our distinguished panelists, speakers, guests of honor, and once again, a special thanks, heartfelt thanks to Honorable Dr. Justice A.K. Sikri. Thank you very much, everyone.
Thank you, Dr. Malik. I now request Advocate Shri Salman Khurshid, who is also the editor of the book, to kindly share his perspective on the book.
I hope that you can hear me now.
Yes, you are audible, sir.
Thanks so much. Very good evening to all of you, but particularly delighted to have Justice Sikri amongst us, because much of the effort that I believe we are making has a great deal to do with some wonderful judgments that he has given during his tenure as a judge of the Supreme Court of India, and therefore his being here is of a great deal of personal satisfaction, and also I believe a great opportunity for what we are trying to do, trying to get the Supreme Court closer to the people of India, so that the decisions that the Supreme Court makes are understood by the people in their true context. It's not always the case that people understand what the Supreme Court is doing and the deep reasons for which the Supreme Court has to decide one way or the other. You may agree with the outcome, you may be unhappy with the outcome, but the point really is the process is the important thing. And an average person not trained in law would not perhaps be equipped to understand the process, and therefore our effort to ensure that the average citizen understands the process and the thinking that goes into a decision. But the particular interest I have, and I greet all my editorial colleagues and everybody else who's made a great contribution. And of course, it's always a pleasure to have my colleague, Mr. Singhvi, there. It's always fearful manner in which we have to deal with him when he's on the other side of the fence, as it were. And it's therefore a sense of comfort that he is on the same side for a change, and we can all both be talking about the same subject. We all have as you all feel it, we have this great respect for Dr. Bakshi, for Professor Bakshi, to whom we dedicated this book in all our humble effort to emphasize the contribution that he's made to the field of law. All the other colleagues I bow to. I have made an effort, and I seek Justice Sikri's personal attention on this. I've made an effort to look at the critical judgments that the Supreme Court has to make about individual rights. And I think there is no gainsaying that in the past few years, some remarkable judgments have come from the court, particularly from the bench in which Justice Sikri has made a major contribution. The rights of the third gender people is, I think, a dramatic forward movement in rights in our country, the right of privacy and documenting the right of privacy through a constitutional bench judgment. Liberty itself has had many attempts by the Supreme Court to provide protection to liberty, but combining liberty with dignity is the exciting work that we are all applauding and we are all celebrating. But I do believe, and I hope that we would be a little bit better informed at the end of this discussion today. I do believe that there is an underlying premise on which rights are upheld. There is, of course, an intuitive manner in which rights are upheld, but there's an underlying premise also of upholding rights. And if that underlying premise is in some way found wanting, then in critical moments, the issue of rights could become somewhat troublesome. It happened before. The underlying premise for rights was somehow inadequate in the past, and we ended up with ADN Jabalpur case, which the Supreme Court itself has overruled after 25 years. But the underlying premise is the greatest good of the greatest number, a utilitarian underlying premise, or is it something different? Or is it, as I have tried to argue repeatedly, that there are rights that people have, that citizens have, that cannot be taken away, and are often described as trumps over welfare. Welfare generally to be applauded and to be encouraged, but there are personal, physical, and intellectual and emotional rights of individual citizens that must not be swept aside by welfare. And therefore, what is the basic premise? I've tried to look at this in Anuradha Bhasin, and I've brought in Dworkin's writings on what to do when security is the issue, security of society is the issue. Can you then truncate rights as they exist? Can you redefine rights? Can you dilute rights because there is a security issue? Is it the balance between perception of security, actual security, and rights? And this is, I think, a very, very, very challenging thing for all of us in the years to come. So I hope that our book, in different ways, will look at issues that are important for the people of India as they look at the Supreme Court as the temple of justice, which they approach in the hope that when everything else fails, the Supreme Court will deliver. Of course, the Supreme Court is also made up of human beings, and human beings cannot be perfect. But as close to perfection as we can see the Supreme Court get is what we hope that the better understanding of its work will be the reward that we seek. With those few words, I welcome you all, and particularly those of you who've been institution builders like Professor Ranbir Singh, a great institutional builder, who I believe will continue to build institutions, including in the area of criminal law. And we all wait to applaud Professor Lokendra when he comes. Thank you very much, ladies and gentlemen.
Thank you so much, sir. I now request Professor Dr. Ranbir Singh to please address the gathering. We have seen your review on the cover of the book, so we would want you to tell us more about the book and how you have assessed it.
Honorable Mr. Justice Sikri, former Judge, Supreme Court of India, respected Salman, khurshid, senior advocate, Supreme Court of India, Professor Upendra Bakshi, a former Vice-chancellor, University of Delhi, Dr. Abhishek, Manu Singhvi, Honorable Member of Parliament, Dr. Malik, Advocate, Supreme Court of India, and other panelists. I feel extremely privileged to join this book launch event on the Supreme Court and the Constitution-An Indian Discourse dedicated to Professor Upendra Bakshi. I admire the editors for bringing out such a wonderful book. I would be running through the common thread which the various writers of various articles have discussed in this book. And I begin with 73 years of constitutional democracy and the rule of law in India is certainly an occasion for taking stock of the great Indian experiment. And that's what is done in this book in the form of the contribution of the Supreme Court and the Constitution. Our Constitution, a nation's dream, has certainly a liberal text and is still even today mandates that vision. If you look around us, there are politics which are plagued with malfunction. Pakistan, Afghanistan, Bangladesh, Nepal, Sri Lanka, Myanmar, and to our north, also authoritative China. We are certainly a great experiment as a country, an oasis of rights and justice in desert of failing or otherwise flawed states. T.S. Eliot wrote in his poem, The Hall of Men, if only between the idea and the reality falls this shadow. India still in deep crisis, as the promises made in the Constitution, starting from its preamble to the fundamental rights and active principles of state policy, our charter and pillars of democracy seem utterly hollow. As for millions of Indian citizens, mere existence of Constitution has no meaning because it does not alleviate poverty, dispense justice to the extent we visualized, provide security, guarantee rights, even equality for millions and millions of Indians known as have-nots in the form of tribals, religious minorities, Dalits, women, and poorest of the poor. Krishna used to call them the invisibles in this country, the fourth world within the third world. These categories sometimes overlapping each other, and they suffer so acutely that they seem to be living in a state which should have more concern for them, where all the organs of the state, the legislature, the executive, and the judiciary have to show more concern about their sadness by taking to more welfare measures for these categories of people, in spite of the fact that the Constitution of India was written in a spirit of good faith by the best political and legal minds. We may criticize the Constitution, may even point out inefficiencies, but without it we would not be colonized, still be colonized, if not by the Britishers, then certainly by undemocratic and communal or other forces within the Indian polity itself. It is better to have a constitution than no constitution at all. We have seen countries where there are no constitutions and what happens to the plight of people. As without that inaugural effort of our founding fathers, we would be nowhere today as a nation. But at the same time, we need to address some serious concerns like attempts to hijack state power, undermine and democracy, disturb the peace and deprive citizens of their rights, and as unconstitutional if we assume a situation where there were no constitution and a strong judiciary, we will be in a position to criticize, condemn, or resist some of the greatest challenges posed by all. We will not be able to do that. And that's why the constitution and a strong judiciary is a must for a country like ours. And they have made very significant contribution. But in principle, since we have a constitution, it is always possible for India as a nation to perform a reality check and pull itself up by bootstraps. The saying during the Nazi regime was anything was possible in the world without the law. Constitution preserves the aspirations that, and in the Indian, at least beyond a point, you cannot desecrate the rule of law because of the Indian judiciary and the constitution we have. The Constitution of India discourse, which have been discussed in the various very scholarly articles, especially one by Mr. Salman khurshid in the very beginning, owed its inspirations and its form to many existing constitutions, but it did not arrive overnight by mail as a textual blueprint of the Republic. It took 3 years almost to be drafted, and the text tried to correct for every problem they could think of. The mixed inheritance of founders of the Republic, modern and traditional India, was in not only for a national revolution, but also a social revolution for an impetus for equality, knowing fully well that neither equality nor fraternity had deep roots in Indian society. There was a word of caution that mere political independence in India does not entail or guarantee Indians becoming a nation in the true sense of the term. So today we cannot pretend that simply writing a constitution was the answer to India's long history of inequality and injustice. We are, as in those famous quote which used to be at the table of the great Prime Minister Nehru, that we have miles to go before we sleep, miles to go before we sleep. The late Dr. D.R. Nagaraj showed us that the Constitution was the most comprehensive attempt ever made to undo caste society and rebuild India on the basis of equal citizenship, fundamental rights, and compensatory social justice. Moreover, more than 7 decades later, the goal of an egalitarian and just society still being elusive, this continues to be a most challenging task before the Constitution. While the Constitution seeks to create a flat community of citizens, the initiative hierarchy of top-rated caste-based politics has posed a formidable challenge as the Indian social reality has gone progressively wrong and as the Republic anticipated, withering away of caste identities has not occurred, but unfortunately quite the opposite has happened. Constitution of the Republic of India, in a country that has produced more text in more languages than any other nation in the world, is still a singular text for those who ask, what can a text do? We need to turn to places where the text has been suspended, neglected, or transgressed. Reasons are not far to find. The country in which it has happened and still continue. One can look at the recent influx of mass humanity, refugees seeking asylum in major part of the world. A text like the Constitution can do exactly what such a text is supposed to do. Make a country like India over 250 years of colonial rule as an independent India. That's a great experiment in itself. Given a very old and civilized culture, the Indian nation, protected by its founding ideas, served by resilient institutions, and fired by new economic opportunities, ought to be able to find a way to allow its people to live with dignity, in peace, and with means and the prospects to do better. Their lot is 7 decades after the founding of the Republic. Millions of citizens still are deprived of their liberty. Then somewhere along the way, India has forgotten that the key to its emancipation lies in its own priceless, peerless constitution and independent judiciary. I will conclude by saying that the rising expectations of the people at the time of the freedom of India should not lead to rising frustrations. Thank you very much.
Thank you. I now request Professor Dr. Lokendra Bakshi to comment on the select articles from the book. Is Professor Bakshi available? Sir, can you speak?
Professor Bakshi is muted. Ask him to unmute.
Sir, can you unmute Professor Bakshi? There was some technical problem earlier. Professor Bakshi, can you please unmute?
Mute. Sir, we can see you, sir.
Sir, you have to unmute again, sir.
Unmute and you have to adjust the camera.
Okay, now?
Yes, sir, you're audible. Just adjust your camera a little, sir.
So that we can see you, sir. Yes,
Okay.
yes.
Better now? How are you?
Yes, sir. Yes, sir. Perfectly all right.
Thank you very much. Well, thank you very much, Mr. Justice Sikri. It's a great pleasure to see you. And Salman, Dr. Ranbir Singh, my good friend Abhishek Singhvi, and Yogesh and Lokendra Malik, and all the friends who come here to applaud this marvelous work. I'm a little mystified that you have decided to honor me again by dedicating this book to me. But I feel that there are more worthy people than me in this field. That's no act of modesty on my part to say that. But I am very grateful to you you have remembered me, and working for a great institution, as Salman said, namely the Supreme Court of India, which is supposed to be in crisis, but I don't quite take that view. And I'll give you a 3 or 4 points because there's not much time. First, I look at Gary Jacobson's introduction. And my friend Gary says, and I go back a long way, when he first started the work on Israel, India, and American Supreme Court, some 30 years ago. Gary says that the court is a complete embodiment of the disharmonies of the Constitution. That's the first two sentences of his introduction. I would rather prefer to say contradictions than disharmonies. And in fact, ushering in the Constitution, Ambedkar said in his famous speech that on 26 January 1950, we enter into a sea of contradictions between social and economic equality, and all kinds of contradictions. He didn't develop other contradictions, a theory of contradictions, but he felt that the Constitution was a product as much of dissensus as that of consensus. And therefore, a dialectical reading of the Constitution will suggest both change and continuity. The second thing I want to say about Gary is he raises a very important question, perhaps another book is due, on this very question. And the question is, if the Constitution itself mandates judicial activism, then judicial process is then mandated as activism itself. So why talk about activism as a separate category? As in now the fashion, why attack or critique public interest litigation as a process? It is already sanctioned by Article 32, if I may, to Gary or Gary said. And thirdly, he says the Nehruvian vision of the Constitution is some sort of crisis. The court, and I quote him, but if Nehruvian vision is displaced and the court proves to be a critical abettor of the transposition, then we should not hesitate in sadly acknowledging that the revolutionary import of what will transpire. Now, what exactly does Gary mean and the book mean by saying there's a fundamental change? Was it distinctive Nehruvian vision? Yes. Has the court departed from it? Have the successors to Nehru departed from it? Yes. In relation to diversity and secularism and inclusion. But we should not forget that it was Nehru who gave priority to directive principle of fundamental rights. It was Nehru who moved the First Amendment even before Parliament was formed. Who said, Constitutional Assembly was itself a parliament as well. And he said, a magnificent constitution, a magnificent edifice, and I quote, is being purloined, is being thieved by lawyers and judges. And what was the First Amendment? The First Amendment of the Indian Constitution, inter alia, included the addition of 9th schedule. And my friend Chief Justice Siddhartha used to say, ours is the only constitution that needs protection against itself. And that's what the 9th schedule is, protection against the Constitution itself by a constitutional amendment. I'm saying, vast number of amendments to Article 31 also occurred in this period. And the court was conflicted with that amendment and chipped into amendments till Keshwanda Bharti came later on and became a full-fledged basic structure theory. Therefore, I would think that if we're looking back at anybody's heritage is bound to be contradictory and complex. And we cannot simply say summarize that heritage in by one value or one action of the person. I thank Salman for reminding us of Ronald Dawkins' legacy, and particularly his idea of moral reading of the Constitution. I think when Salman quotes Nauset Johar, I draw his attention to everyone's attention to one significant part of the quotation he makes on page 7. And the last sentence, the reference is made to questions of political morality. And that very same court, Supreme Court to Justice Kaya, did in fact develop the idea of constitutional morality, which I call CM. Now, I'm not a politician, so let me not get that area. But CM conflict with PM, popular morality, PM1 and PM2. Popular morality is constitutional morality and people's morality. The third condition is made by Nauset, which is political morality. So if you oppose CM as a concept, then you can't applaud PM as a concept, PM3 as a concept. And my final comment is I learned, and it's a takeaway of a lifetime, I think. Salman, very good. I must quote you and violate your copyright. You say our national metal will be firmed up by meticulous observation of principles of the Supreme Court as sacrosanct and not casual imperviousness about injustice. This is a beautiful phrase, casual imperviousness about injustice. Because you say accountability is, I quote you, too late and too late. And that's the real problem. You hit the nail on the head of a real problem, that is accountability and casual imperviousness about injustice. And I thank you for that. Now I must end quickly, if I have 2 more minutes. I've read almost entire book, and I compliment everybody. But I focus on 2 3 aspects. One is, Yogesh, you, I think, based your whole article. It's a very interesting article. I learned a lot from it. But you seem to be saying, and correct me if I'm wrong, you seem to be saying that the present process of appointment of judges, elevation of justices, violates the constitutional principle of seniority. Well, my mind will always the principle of seniority come merit. I think you come back to it. And it's a merit should not, I hate to use the word seniority. It's a bit difficult nowadays to speak any English properly. And I think Salman also must watch out when he speaks about trumping, principles trumping, rights trumping the other thing, public policy. I think the only question I wish to raise for future is there a constitutional convention? Is that written in stone or is it written in sand? Is there a convention? Between stone and sand, there might be variations. And if it is not a convention, then what is the difference between the world of executive, which makes the appointment, and the world of judiciary? There is no difference, because a citizen would never know why a particular person is appointed as a judge. There is no way. And I think there is always a discretion involved in any appointment, as you know and I know, in universities. And therefore, the only question is, are there any really regressive appointments? No matter who appoints them, or what the convention is, are there really bad appointments? Bad, which could have been anticipated by judges making appointments, by the executive concurring with. And I think that comes through what you said. Finally, I think I not much time. I'm sorry, I'm exceeding the time. Is this whole business that Lokendra is referring to, like quite rightly, of post-retirement jobs and transfers and appointments in some other way. I have no difficulty with your thesis, Lokendra, but I have difficulties with the almost entire book, if I may say so. And that's my final word for time. The difficulty is simply, we are talking among friends, it was looking at a future work of this kind. And general difficulty is the lack of reference to empirical material. For example, the marvelous study done of how judges have accepted post-retirement jobs from the word go till now. Empirical study, and they have found, they have rightly or wrongly come to the conclusion that they have some effect, although not attributed actually by other people, by media and by scholars, have some effect on judicial independence. So I think it's important to include the empirical observations along with the material. As you know, you've done a book on delay and dissent and so on, and you know how it is done. I think in future, we should encourage empirical work on the Supreme Court, as well as the normative work that we are doing. And the two together, the confluence would be, I think, in future relevant for other books. Thank you indeed. I don't want to review the book. I enjoyed it. And these are some off-the-cuff observations. I'll read again, and I hope I'm sincerely wrong in all things I've said, which might seem to be critical, but which are really not meant to be critical. Thank you indeed, and thank you again for the marvelous question. Thank you again.
Thank you so much, sir, for your feedback on the book. We will now move on to the address by Dr. Abhishek Singhvi, Honorable Member of the Parliament, and we would want to know your reviews about the book from the perspective of a parliamentarian.
Thank you, Madam. All my esteemed friends, Honorable Justice Sikri, Professor Upen Bakshi, my friend Salman, Lokendra, Malik, Yogesh Pratap Singh, Professor Ranbir Singh, everybody. Seeing the list of names, I was reminded of the phrase, the list of names in today's function. I was reminded of the phrase, the usual suspects. Because I say so also because a very similar combination of us spoke at another fetch script for the same man, Upendra Bakshi, in February of this year. Of course, at the rate at which Professor Bakshi is collecting fetch scripts, he is soon going to establish a record. This is not formally a fetch script, it's a dedicated book, but I count it in his long and seemingly endless list of fetch scripts by admirers, by students, by friends. Let me therefore start by quoting a few lines I said about Professor Upen Bakshi at that fetch script in February this year. And I said, among other things, that I always thought to myself that Professor Bakshi was born to be not only a professor and professorial in looks, mannerisms, style, dress, and so on, but his lock of somewhat unruly hair, and I find that that is very well preserved, orderly, unruly hair, even today, his archetypal pipe, which I find missing, but his slow and measured drawl, his muffler, a little early in the weather for that, all reminiscent to me as a younger man of the quintessential academic. And as I said that day, for a while I suspected him of corrupting my father into pipe smoking. But so wonderful was the aroma of that rich brand of tobacco that I can confess, and so hypnotic was the sight of cleaning it, like a Japanese tea ceremony, a catharsis in itself, that I must confess that I almost started pipe smoking. But Dr. Bakshi has always been a great thinker, a very creative brain, And you can see that he has lost none of that creativity. In the L.M. Singhvi Memorial Lecture, he used this beautiful alliterative trilogy of legisprudence, of jurisprudence, and demosprudence, and then went on to expound it in very, very interesting terms. Well, friends, and I'm not in Delhi, so I've had only a limited time to see a PDF copy of the book. But as I turned to the table of contents, what struck me was the very interesting, the very innovative, bold, candid, and catchy use of the titles in the table of contents. In particular, what caught my eye was serial number 5, post-retirement, judges' issues. 6, lordship versus ladyship, gender diversity. 8, administrative issues with the CJI as the master of that particular set of issues. 10, curative rule or ruse. 12, what I've called an unruly horse for a long time, they call it the PIL, pill for every ill. Then the CJI in 14 as the master of all conventions. And then 15, the Prashant Bhushan case, very nicely described as response to a tweet by a 108-page judgment. Some of these, of course, may not be classed as scholarly law school curricula items or subjects. But that is precisely why they are both important and interesting. Because what they do not teach you at Delhi Indian universities is sometimes the more important part of the legal system and not merely of law. So let me address some of these elephants in the room, which my careful, cautious, and wise co-panelists have perhaps deliberately avoided doing. The first is the issue of post-retirement employment of judges. I do sincerely believe that it must be controlled in some way. I have no clear answers, frankly, but I'm certain that the present system is most unsatisfactory. It, first of all, appears to have no methodical, systematic methods of selecting the vast numbers of our judges retiring, and I'm not talking of Supreme Court alone, but also of the high courts. Seems to be based very much on a pick and choose system, an approach Chief Justice of that institution, be it the High Court or the Supreme Court. It is not based either on seniority or on expertise or on aptitude for a particular tribunal for which that selection is being made. And though nominally it is done by committees headed by the Chief Justice or his nominee, and I would imagine, and probably Justice Sikri would know better, 99% of them have Chief Justice nominees. The Chief Justice rarely sits on the actual committee. Selection is very heavily controlled by bureaucrats and influenced by the executive, even though nominally a judge is heading it. So here there is a legitimation function being performed almost inadvertently, because the judiciary lends its approval stamp, and yet the executive has its way in many cases, which is obviously the best of both the worlds for the executive. Personally, I think the other oddity in our system would also tackle this issue of post-retirement tribunal appointments, etc., to some extent, possibly to a large extent. When I was chairman for some years of the Parliamentary Standing Committee on Law, we had written the first report saying that this very strange anachronism of the 62 to 65 arbitrage in age between Supreme Court and High Court judges should be done away with. And it arises from some old myth, a complete illogical kind of approach that you must tie it to some retirement ages of the bureaucracy or sections of other services, which is not at all the case with the judiciary, which is a separate organ. It's interesting that my report is now about, I think, if I remember, at least 8 years or more old. And there have been reports earlier. I was chairman of this committee 8 years ago, the Parliamentary Standing Committee. But this arbitrage, this hiatus continues. It has continued for decades. It is treated as a hierarchy differentiating system as if 65 retirement makes the 65 retiree superior to the 62 retiree, so that when we send this for inviting responses, we found that yes, some responses said yes, please do increase everybody to 65, but then make the Supreme Court judge 67. Now, the purpose of this is that a lot of people look for these post-retirement sinecures, sometimes inappropriately, because you are retiring a batch of very high superior court judges, after all 226 in many ways vast power, at an age which is completely inappropriate, leading to a lot of unsavory practices, and I don't want to repeat them, which every judge knows about. Justice Sikri surely knows about them. A lot of the unsavory practices happening by claimants to this kind of a lobbying between the 62 and 65 age. So this is something I am still surprised as to why it persists. And I think it's time where we just simply did it without keeping this distinction and stop consulting. The other thing which I want to talk about very briefly before I end is a subject not found in this book, which I think is an omission, which should be rectified in a supplementary volume. This is published bang in the middle of COVID and deals with a lot of issues of administration of justice. Perhaps it should have addressed, partly statistically and partly qualitatively, the issue of administration of justice, especially in the Supreme Court and High Court, and also in the lower courts during COVID times, whether what we are doing for the last 6-7 months is right, and what is the roadmap for the future. My own view on this is that our existing virtual facilities must be ramped up considerably. And this is a ramping up required in the quality of the software. It is a ramping required in the quantitative load which it can bear. And I'm now talking from the practitioner's viewpoint, what one would not find written about otherwise. To give you two examples, you find a bewildering, almost amazing diversity of software in the 20-25 high courts. I myself use at least 10 softwares in 10 different high courts, from Blue Jeans to Jitsi to, of course, WebEx, to so many others, including the Delhi High Court as one of the best ones. I have yet not understood why the best of them, which I think is the High Court of Delhi's one, is used across the board. We've had, for example, recently appearing in the Telangana High Court for the Amravati capital city trifurcation matter. And these systems work the worst when there are batch matters. They just cannot accommodate and handle batch matters. The whole system crashed innumerable times, so much so that the hearing has been delayed now for 2 months and is now probably going to be only physically, which excludes many of us. These are varying qualities from Allahabad High Court to Jaipur High Court, from Odisha High Court to Bombay High Court. And I've yet not understood why a module and a protocol for this is not set up. Secondly, I think we have functioned, despite all the self-congratulatory pats on the back, which every court tends to give itself, despite all the press releases we read about what a great number of cases are being dealt with. We have functioned at best in less than 50% of our capacity, whether it be the Supreme Court or it be the High Court. It's only recently, last week, that for a particular week, all the full strength was functioning. But I think that was certainly not the paradigm for all these months. And that is not the paradigm which has been designed to be able to be conducted. When you go down to the lower courts, it is much worse. The lower courts, including courts in Delhi, so within Delhi, within a state and interstate, you have great variations. A Patiala House courts functioning on the COVID platform may be very different from a Saket courts or a Tisari court. I'm talking of actual experiential issues. And when the numbers are slightly larger, I find systems crashing. I also believe that had virtual courts been properly thought of in these times of crisis, there is no reason why each court would not have 3 or 4 tracks or 2 or 3 tracks devoted only to old final hearing matters. The truth of the matter is that during COVID times, filings have lessened, load has lessened. And this was the time when virtually you ought to have kept 2 tracks of judges, at least in each court, attacking the 10-year-old matters, the 20-year-old matters. Yes, it would be resisted by the bar for a while. Yes, you'd have to give 1 or 2 warnings. But the 3rd warning would say that if you do not attend to these old cases, we will decide anyway, and you'll have people turning up. Now, this could have been done very well in the last 6-7 months. It has not been done. I personally believe that we should continue with at least a 33% paradigm of virtual hearings even after this pandemic scourge is over. Virtual hearing is actually a very effective, very efficacious, in many ways much more efficient. And while physical is being demanded from diverse quarters, even when times are normal, I don't see any reason why you cannot have exclusive tracks put down for virtual hearing, and there will be a large class of people who would be happy to work on that track. I don't see much thinking along those lines. One myth was startlingly exploded recently when, on the basis of huge outcries from several quarters, physicals were started for 3 courts or 4 courts of the Supreme Court, and indeed for some courts of the High Court, Delhi High Court. Why I say that one myth was exploded is because the actual attendance and the demand for such physical courts was counted as less than 1% of the entire class of lawyers who were supposed to be appearing. So I think it is wrong to suppose that lawyers are clamoring in large numbers for physical. Lawyers also want safety and convenience. Yes, there are problems of logistics. There are classes of lawyers who need assistance, but that can easily be managed by providing for a small window of those who must do physical because they don't have the facilities. But to suggest that the whole country is overwhelmingly wanting a physical hearing at the exclusion of virtual hearings is wrong. My last point is about that chapter titled The Response of a 108-Page Judgment to a Tweet. The contempt set, and I have not read the full news, the contempt issue in that case, I think, left much to be desired. And I am not speaking on the merits at whether you think that the accused was wrong or that the court was wrong, that doesn't matter. I think the methodology, the approach in that court was a huge casualty. It, in fact, diluted the efficacy of the very power, namely the contempt power, which the court was seeking to uphold. The manner of picking up a tweet case with another old case and putting them up together raised a lot of questions. The manner of doing so when it was known that the tenure of one of the judges on the bench was ending very shortly was the second wrong. The manner of adding yet a 3rd case to that batch, which was even older, compounded, I think, and ultimately that 3rd case was left undone. And I think the accused, in fact, was allowed to dare and to utilize a dare, and in fact somewhat in the dare he gave, because ultimately the sentencing allowed him to claim martyrhood. So I think these are all lessons to be learned about contempt jurisdictions as well. And I think that treatment of the subject also is very useful. May I end, friends, by saying that one would wish Godspeed to all the stakeholders of this book, and of course to the person to whom it is dedicated, as also the editors, and in particular to Mr. Lokendra Malik, who is the midwife for so many good causes. And I would end with the fond hope that the Supreme Court should look into, should dwell upon and reflect upon books like these. They are not meant to be carping criticism. They are not meant to be negativism. If you dwell and reflect and partly some of the suggestions in the different various issues of administration of justice found in the book, you will only improve the justice delivery system, which is the object, obviously, of all the stakeholders in this system. Thank you very much indeed.
Thank you very much, sir, for your valuable input. We now move on to the much awaited moment of the event, that is the address by the chief guest and the book launch. But before that, I request all the panelists to kindly mute their computer screens. So now I call upon Honorable Mr. Justice A.K. Sikri to please deliver the keynote address, and then we will launch the book. And kindly all panelists, please keep the book with you for its launch.
Thank you very much and inviting me on this occasion for the launch of this book. And my last minute addition to this great panel, I will come to that little later and respond to what Mr. Lokendra Malik or Professor Lokendra Malik or Dr. Lokendra Malik said. But I'm thankful to the organizers for giving me a chance, and more particularly to listen to these stalwarts. My own revered Professor Bakshi, my erstwhile colleagues or those who were colleagues with me in the profession, Dr. Singhvi and Salman Khurshid, were the Vice-chancellor, or now maybe technically called ex-Vice-chancellor, but I take it a pleasure that I was in the selection committee which selected Professor Ranbir Singh as the Vice-chancellor of NLUO Delhi, and he has done a stupendous job as the first Vice-chancellor, as everybody acknowledges. Dr. Lokendra Malik and Dr. Yogesh Prasad Singh. And my best wishes to all those who have joined this occasion today. This title of the book itself, I would say, evokes much inquisitiveness and much debate. It is Supreme Court and the Constitution. So the two aspects which are stated there, on the one hand, the Constitution and what the Constitution envisaged and what is the philosophy or the vision of this Constitution, and other is one of the organs of the state, which is the creator of the Constitution itself, that is the Supreme Court. How far it has been able to do its job in order to uphold that Constitution, or as it was stated by Professor Bakshi, that the Constitution needs protection against itself, and which becomes the job of the Supreme Court. So in that direction, how far it has been able to do its job or its duty or its function, this has been the matter of debate all along. For last 30, 40 years, we have been seeing various studies which have been made. But of course, most of these are doctrinaire studies, as Professor Bakshi said, and very less the empirical studies. But at the same time, the role of Supreme Court has been discussed time and again. But in spite of this, the present book, as the earlier all distinguished speakers have said, is a distinct book of a different kind altogether. And it has chosen few subjects that I will come to. But then the first question, as I said, is what is that we gather from our Constitution? To this august gathering, I need not say much. As we all know, our preamble to the Constitution itself captures the essence or the philosophy of the Constitution when it talks of justice, liberty, equality, and fraternity. And interesting thing is that, yes, these are the objectives which our Constitution makers wanted, and this is what is to be achieved. But at the same time, the clear objective in enacting this Constitution by the Constituent Assembly was to shape Indian democracy in a liberal mold. This is what I want to emphasize. The entire thing was just, we need not only a formal democracy, but a substantive democracy, which should be a liberal democracy. And the founding fathers were largely influenced by the principles of Enlightenment philosophy and also constitutional practices that liberal democratic qualities, which was, recognized also during the Constituent Assembly debates, like Australia, Canada, United States, and Ireland. I want to quote, or not quote, rather refer to Dr. Ambedkar's speech, which he gave on 4th November 1948. It was his, in the Constituent Assembly, where he discussed two important aspects of the Constitution. That is, what should be the form of the government and what should be the form of the Constitution. And of course, he discussed about the form of the Constitution, where the president has to be the titular head, with the prime minister, this British system, which was adopted as far as the Westminster system. But then when he talked about the Constitution, he talked about the federal Constitution. But apart from all this, very important thing, and which was highlighted, and it has become, I think, a very dear subject insofar as Professor Bakshi is concerned, that is the constitution morality. And interestingly, Dr. Ambedkar talked of this constitutional morality even at that time in 1948. And he stated that the spirit of constitutional morality, which is articulated as the reverence to this critical ideological values which are fundamental to a constitution, is the most important and stable constitutional democracy. So he talked of this, that this is what we have to do. And when we talk of transformative constitutionalism, when we talk of a constitution which is a vibrant document, and it is not a static document, constitutional morality becomes inherent in it. And therefore, the three, cardinal principles which were also adopted by this side were liberty, equality, and freedom, which are there. And in the same breath, Dr. Ambedkar also emphasized on safeguarding the minorities. I'm intentionally focusing on this because on that basis, I'll come to this book, and what is, as Dr. Singhvi also said, that what is happening in these days or COVID times, etc., although not captured in this book, but which becomes very relevant insofar as the role of the Supreme Court is concerned. And so apart from that, he also talked about minorities' rights of Dalits. And therefore, we find on the one hand, there is a chapter on individual freedoms, that is fundamental rights, etc., of citizens. And on the other hand, we also have chapter like directive principles of state policy, which talks about the welfare society which is to do the justice to the marginalized section of the society or downtrodden, as was stated by Professor Bakshi also, that this debate where Nehru always gave primacy to the directive principles of the state policy. But what I want to say here is that, look, here our constitution imbibes in the constitutionalism which is there, both negative and positive aspects. Insofar as negative constitutionalism is concerned, it talks of limited government, where individual freedoms or individual fundamental rights in chapter 3 are to be cherished and they are to be upheld. On the other hand, we have chapter 4, which in a way talks of positive constitutionalism in the sense that it talks of social welfare, solidarity, economic equality, and social justice. And as I take it, that between the aforesaid two sets of constitutionalism comes the rule of law, and which aims at achieving both the aspects of constitutionalism. Here, the role of, so if this is the edifice of our constitution, this is the philosophy of our constitution, and as I said earlier, that even there are three pillars of any state which are there, the creature in our constitution, also the legislature, the executive, and the judiciary. So in that sense, Supreme Court itself is the creature of this constitution. But the function which it is assigned is that in the form of judicial review, not only of executive action, but even of the legislative action. So therefore, in that sense, in the form of judicial review, it becomes the protector of the Constitution. That what Professor Bakshi also highlighted. So therefore, in what way the Supreme Court, and then I come back to the title of the book again, that on the Supreme Court and the Constitution. So therefore, there can be various facets of now the role of the Supreme Court, whether Supreme Court has been able to adhere to the principles of separation of powers, because since it's a creature of the Constitution and it has to act within the limits of what is provided in the Constitution, whether it has overstepped the question of the judicial activism, etc., all those issues arise when we talk of this. On the other hand, when we talk of when I told about the fundamental rights on the one hand and judicial philosophy of welfare, etc., on the other hand, and in that context, if I quote Haran Barak, the ex-chief justice or the president of the Supreme Court of Israel, who said that there are two fundamental roles which any judge in a democracy, constitutional judge, has to perform, and we can say in our context that the Supreme Court has to perform in today's context. That is, on the one hand, it to uphold the Constitution and the rule of law, democracy and rule of law. That is one. And two other aspect is to bridge the gap between the law and the society. And in the second aspect, we talk of positive constitutionalism. So therefore, that is what is to be seen. And I think that that was the objective in mind as far as the three brilliant, I would say, editors are concerned, Mr. Salman Khurshid, Mr. Lokendra, Malik, and Yogesh Pratap Singh, who have come out with this book and the idea of this book. Good thing is that all three of them have also contributed their chapters, apart from seeking contributions from the other. And another best thing which others have also said, I'll repeat and I'll join that chorus in saying that dedicating this book to Professor Bakshi is another, I would say, a remarkable step, or the this attitude of the three editors. As I see the book and the chapterization thereof, what I feel is that they are broadly, because as I said, there may be various topics which can be discussed. One, even Dr. Singhvi has said that during COVID, how it could be, which is not here. There may not be many other aspects also, because it is not possible to include each and every aspect of the relationship between the Constitution and the Supreme Court, because on most of the topics are such that a complete book can be written on that. But I will still admire the editors in picking up, according to me, the four main subjects. First subject is about the freedom of the individuals, which starts with the chapter or the essay of Salman Khurshid, and as he rightly says, its role, Supreme Court's role in developing the rights jurisprudence. And here, if you see in this would come, apart from his what he has written, the other topics which we may include is about the chapter 6 on the gender diversity. Then because even when we are talking about the appointments, giving women their right as far as appointment is concerned becomes an issue of equality as well at the same time. Of course, it has both the facets, and then the second facet also I'll come to of this chapter. But then this chapter 9, which talks of excluding minority institution from RTE Act, because I feel that right to this, as far as RTE is concerned, it is again a facet of individual rights, and here question is about the minority institutions, etc. And chapter 15. Chapter 15 is on the which Dr. Singhvi has also stated when this it's on that power of this contempt power in Prashant Bhushan's case, because that is related to freedom of speech and Article 19(1)(a), and to what extent the Supreme Court should go, because it is also a matter of great debate. Second, I would say the subject which is chosen is about on the social justice or the welfare justice. And here I would include chapter 7, which is role of Supreme Court in arresting social democracy, and chapter 11, which is on citizenship, refugees, and Supreme Court, which that is stated. And the third is, which may be overlapping with the first topic, is about the this judicial activism. In that, but it goes along with that, of course, the first two topics which I have said, and where chapter 3, chapter 10, and chapter 12 would fall in that. And including this chapter on PIL, because PIL becomes one of the instrument of advancing social justice in that sense, or even advancing the human rights of the deprived and unprivileged section of the society. And the fourth topic relates to the administration of justice. And it would, I will say that this is the functioning of the Supreme Court itself. And in the administrative sense, when I say it comes that the appointment of the judges, their post-retirement jobs, etc., which is stated. And in a way, it also touches upon the impartiality and independence of judiciary. Those aspects, they come in, which is one of the basic features of the Constitution. And as it is said that it's not only the decision in when we take judicial review of the administrative action, the fundamental principle is the decision-making process, which is more important, to which Dr. Singhvi also highlighted while commenting upon this Prashant Bhushan's case. And in last few, if you see, in last 1 or 2 years, many actions which have been taken by the Supreme Court, whether on administrative side or on judicial side, there's more criticism on the way it has happened. Like in the Prashant Bhushan case, he has highlighted. I can highlight many other cases also. I'm intentionally not doing that. But if you see, if I give hint, at least to this extent, which Salman also has stated at the end, in respect of what is happening as far as CA protests are concerned, Article 370 is concerned, and even this UAPA charge sheet, etc. So the main criticism of the Supreme Court is not taking up these cases, which happened to some extent, and Professor Bakshi has also written a wonderful article on the exodus constitutionalism, when the migrant labor, they needed an immediate relief, and the Supreme Court did not take up the issue for months together. Of course, ultimately it took up that issue. So therefore, this also becomes very, very important. And I'm not commenting on most of these articles, as I also got the book only day before in the evening. So I had only one day. I've gone through 3 or 4 chapters in that book, including the first chapter written by Salman. I would only say one thing insofar as Salman's chapter is concerned. He is right when he talks of the rights jurisprudence. I would say even in this Anuradha Bhasin, where the Supreme Court has adopted the earlier the methodology which has already been adopted on the proportionality. Proportionality today, according to me, becomes, and it is by now what has been invented by the courts. It started in this doctrine of proportionality in German, by the German Supreme Court, again Canada Supreme Court, but now it is all over. Europe has adopted, even America to a limited extent, and we have also in last few years, in many cases, this has been adopted, and it is a much better improvement than the word reasonable restriction, which is stated, and how reasonable is restriction is to be interpreted. So it lays down much better norms. And of course, concern of Salman Khurshid, I would understand when he says that it seems little impact on police forces of several states prosecuting in spite of LGBT judgment and Navtej Johar and privacy judgment. That is the concern where he expresses. And even in Anuradha Bhasin, what I would say, according to me, where the Supreme Court faltered was after laying down all these principles, instead of deciding itself whether the restrictions which were imposed or 4G, etc., which was not given in the state of Kashmir, in order to, when the judicial exercise of judicial review, the court would have then gone into this issue whether this restriction is reasonable or not, and whether it meets the doctrine of proportionality, instead of giving it back to the executive to decide that. Because why it should be given to the executive? It is the executive function which is under challenge before you. Now you say that this is the proportionality, and now executive becomes the judge, which has to decide over its own decision which was taken whether what we had done was right or wrong. Had Supreme Court decided it itself and had applied that proportionality, what would have been the decision? I'm not going to say here, but then much of the problem could have been solved even in that case. But having said so, I must appreciate the three editors, as I said, who have really produced this wonderful work. And as I said in the beginning, that I'll come to that aspect why Lokendra Malik did not involve me in the beginning. I was wondering when I came to know about this venture of Lokendra Malik and other two editors, because normally he has always involved me in last 5, 6, 7 years in every, at least either I write a prologue or epilogue or forward or contribute some article. Here I was not even talked about. Maybe here they were, as was said by Yogesh Pratap Singh also, that our essays are a critique or a severe critique to the functioning of the Supreme Court in certain on certain aspects, and therefore maybe Lokendra Malik thought that a person who had been a part of the Supreme Court, we should not associate him, because it is not only venture, it is adventurism. And but what I would say is that had you told me and involved me and asked me to write a chapter, I might have written on myself and critiqued myself that where I failed as the judge of the Supreme Court, and I could have done better. Anyway, on that note, I congratulate all of you, and you're right, it is going to be a wonderful read. And as Dr. Singhvi and Salman has also said, that it is not criticism of the Supreme Court in that sense, that and it should not be taken in a negative sense. On the contrary, there is always a scope for improvement, and therefore it may be it may show some way, some light to the Supreme Court also, the present Supreme Court also, particularly in COVID conditions. When we talk of Dalits, what is happening in Hathras is an example. When we talk of Dalit, as I gave the example of this migrant laborers. Now, these are very, very important issues which are arising during COVID. Of course, Dr. Singhvi mainly talked of the process and the manner in which the courts are functioning. And he would be one of the happiest persons as far as virtual hearings are concerned, because sitting in his room, he can at the same time appear in 5 or 6 high courts as well as Supreme Court, which was humanly impossible if it was a physical hearing. So therefore, a person like Dr. Singhvi has gained a lot because of these virtual hearings. But at the same time, I would say that it is also good for the judicial system, as the acumen or the expertise of persons like him, and Salman Khurshid and many others is available at the same time to all high courts as well as Supreme Court. So these are some of the thoughts which came to my mind. And so congratulations to you as well as to the publishers, Wolters Kluwer, on this. Thank you very much.
Thank you very much, sir. And as a part of the launch, I request all the panelists to kindly hold the book with them so that we can take a picture. I will try to change this to grid view.
Pardon for holding a virtual
Constitutional Law Society, I request you to please take a picture. Thank you. Thank you, everybody. I now request Mr. Sirish Sahai, CEO of Walters Kluwer India Private Limited, to please deliver the vote of thanks.
Honorable Justice Sikri, Professor Upendra Bakshi, Dr. Singhvi, Professor Ranbir Singh, Mr. Salman Khurshid, Dr. Lokendra Malik, Professor Yogesh Pratap Singh, and all those who joined us today. After listening to all the speakers, I must say, for me personally, this was a very deep and educative discussion. Over the last few years, civil society discussions have increasingly featured the Supreme Court and its decisions. While the legal scholars participate in these discussions with their informed opinions, most of the public untrained in law may not have enough information to contribute effectively. As we heard from our speakers, this book is an attempt to bridge this gap. I'm glad that Walters Kluwer is able to publish this book, which will be of great help to anyone who wants to understand judicial decision making in the Supreme Court better. For those of you who are not familiar with the Walters Kluwer, we are a global organization with a 180-year history of helping professionals make better decisions across industries. Some of our solutions include Kluwer arbitration, Kluwer competition law, Kluwer international tax law, which are gold standards when it comes to their respective area of focus. I would like to thank our esteemed chief guest of this event, Honorable Justice Sikri, for joining this event and sharing his thoughts. I wish also to thank our special guest, Professor Upendra Bakshi, for his presence and participation. Then our guests of honor, I would like to thank Dr. Singhvi and Professor Ranbir Singh for their educative and thoughtful comments. Next, our editors, they have done a tremendous job on this book. I would like to wholeheartedly thank Mr. Salman Khurshid, Dr. Lokendra Malik, and Professor Yogesh Pratap Singh. I hope this book becomes an indispensable companion to all readers interested on this topic. And finally, a special note of thanks to Professor Yogesh Pratap Singh for leading and organizing this book launch webinar. Take care, stay safe and healthy.
Thank you very much, Mr. Sahai. As a parting note, I would like to inform all the participants that the book is available in Kindle form on Amazon. It is available as ebook on Tax Sutra Reservoir and also available for pre-orders for hard copy at Bharati Law School, Law House and other online platforms also. And it is available at a very affordable, student-friendly price. So thank you, panelists. Thank you, dignitaries, everybody, for being a part of this event.
Risika, I would like to say thanks to you and Professor Yogesh Pratap Singh, and a special thanks to 4 eminent professors who have contributed blurb messages to the book. Professor Dr. Ranbir Singh, Professor Manu Sinha, Professor Balram Gupta, and Professor Dilip Uke. And once again, to all our distinguished chief guests, guests of honor, and my guru, Mr. Salman Khurshid. Thank you very much.
Thank you, sir.
Thank you, sir.
Thank you very much on behalf of Constitutional Law Society.